Welcome, everyone, or welcome back to Quadrant Chambers. It's time for our annual look back at arbitral developments over the preceding year, to give our audience a bit of a post-Christmas refresher and to consider what might be coming over the horizon. So for those of you that don't know me, I'm Claire Stockford. I'm a barrister and arbitrator here at Quadrant, and I will be your moderator for tonight's event. So before I introduce our speakers, I'm just going to share a couple of my own musings about 2025 from an arbitration perspective. So although the year was not dominated by one significant decision that has the whole arbitration community talking, like P&ID, 2025 has nonetheless generated plenty of material for tonight's event, not least the introduction of a new Arbitration Act in England that I know is going to feature in some of the presentations, and reflecting the broad satisfaction with the old Act, the 1996 Act. The new legislation has generally been described as evolution rather than revolution, but it does contain some significant changes for practitioners, as will be touched upon. Another interesting development is the snappily named CPR PD51ZH. Now I know it just trips off the tongue. What relevance does a CPR pilot have to arbitration? Well, this pilot permits a broad range of documents to be made publicly available by the courts, and that includes skeleton arguments, written openings, closings, witness statements, expert reports, and any other document deemed critical to the understanding of the hearing. And in the pilot, these documents are going to be available by default rather than via an application to the court. So one of the main drivers towards arbitration rather than court litigation has always been confidentiality, and arguably this pilot provides additional impetus to push parties who want to keep their disputes confidential towards arbitration. So I'm not going to go into more of the developments in 2025. I'm going to leave that to our wonderful panel. So let me introduce them to you now. So first to speak, we will have my colleague Maya Chilaeva to my left, who's barrister here at Quadrant. Her year of call, 2020, belies the breadth and depth of her experience. She has broad commercial practice, including both international arbitration and commercial litigation, and has appeared at every level of the English court system, including in the Supreme Court. She also acted in the well-known case of Churchill and Merthyr Tydfil in the Court of Appeal on ADR. That will be familiar to many of you. Maya is going to look at some of the recent cases on anti-suit injunctions. Maya will be followed by Simon Rainey KC, who is a silk here at Quadrant and really needs no introduction, but that's not going to stop me.
Because I'm so old, ladies.
His practice encompasses commercial litigation, shipping, commodities, as well as international arbitration. He's previously won International Arbitration Silk of the Year at the Legal 500 Awards and has an enviable track record in commercial court challenges to arbitration awards under the Arbitration Act. According to a comment in Chambers 2025, you just sit, watch, and admire his ability. So I invite
downhill from here on, ladies.
So I invite you to do just that this evening, as he runs through some of the most significant developments of the last year relating to challenges under the Arbitration Act. Then we move to the first of our guest speakers, Reza Mohtashami KC. A partner at Three Crowns in London, and also a member of their new Dubai office, I understand. Reza is a solicitor advocate. He's been recognised as a global elite thought leader in arbitration by Lexology Index and has been described as a market leader. Much of his work is in the investor state sphere, and he has represented clients in many prominent cases, including securing an award of almost $2 billion in the present petroleum arbitration. He is going to look at how the New York Convention is being used by parties using the Star Hydro case as his context. Our second guest speaker is Sam Rowe from Debevoise and Plimpton in London. She is an English solicitor. Her practice focuses on international arbitration and public international law. She's represented clients in many prominent arbitrations, including acting for Hess in its victory against ExxonMobil and ISA Infrastructure in its successful exit arbitration against Spain over the withdrawal of its renewable energy incentives. She has many accolades, among them that she has been named on the Lawyers Hot 100 list and also named a Rising Star by Law 360. She is going to look at some of the investor state cases that have touched this jurisdiction over the past year. But we clearly have a lot of ground to cover and just over an hour to do it in. So without further ado, I'm going to hand over to our first speaker, Maya.
Hi everyone, it's really good to see so many of you here. So to set the scene for our discussion this evening, arbitration-related work continued to keep the commercial court busy in 2025. The number of new claims is broadly in line with previous year's figures, so they account for about 20 to 34% of the commercial court's business each year. And that's on top of the London Circuit Commercial Court figures, which are also increasing year on year. The largest slice of that work are challenges under sections 67, 68 and 69 of the Arbitration Act, and Simon will be speaking about key developments on that shortly. The next main categories are applications to enforce arbitration awards and applications in support of arbitration, which is the focus of my talk. And specifically, I want to focus on anti-suit injunctions and the governing law of the arbitration agreement. So in this area, the most important development, in my view, over the past year has been legislative rather than there being a big blockbuster case. And now stick with me here because some of the material can sound a bit technical and quite dry, but underneath it all, there is a matrix of really important points of principle and policy. So many of you will be aware of the new rule on the law governing arbitration agreements under the 2025 Act. So I'll touch on that first. And then I'll speak briefly about the related but distinct area of anti-enforcement relief by reference to a key 2025 case. And I'll return to this at the end, but the three key takeaways from today are that, first of all, English courts have made it easier to achieve jurisdiction in certain cases. Secondly, when applying for anti-suit and anti-enforcement relief, it's important to be aware of the international dimension. And last but not least, courts will give weight to considerations of comity. I want to start with the international context. The point that we're seeing more anti-suit injunctions globally was highlighted at the meeting of SIFOC in Delhi in November last year. And for those of you who don't know, SIFOC is a global network of commercial court judges from over 70 jurisdictions. And at the meeting, which I attended, they discussed areas of potential judicial cooperation. And the area of anti-suit injunctions was one of the candidates proposed because of the concern that it was causing problems for transnational corporate entities who faced conflicting anti-suit injunctions from different jurisdictions. And it was suggested that one of the factors driving this was divergent approaches for determining the implied law of arbitration agreements. So one well-known example is the Kabaji case, where the English and French courts reached different outcomes regarding the enforcement of arbitral awards. So against that background, the 2025 Act makes an important change to the default rule on the law governing the arbitration agreement, and that's the new section 6A. The rule is straightforward. If the parties expressly choose a law for the arbitration agreement, that law applies. If they do not, then the default is the law of the seat. And a choice of law for the main contract does not count by itself as an express choice for the arbitration agreement. So that replaces the more complex Enker and Chubb analysis. And so to illustrate that change, I want to compare two pre-2025 Act cases with one that came after. The first two will, I'm sure, be well known to lots of you, which was it's the Ruskhem Alliance cases against Deutsche Bank and UniCredit. So in each case, the bank guarantee was governed by English law, the seat was Paris, and Ruschem brought proceedings in Russia. The banks then applied for anti-suit relief in England to protect the Paris arbitrations. And applying the Anchor test, the court treated the arbitration agreement as governed by English law, because the main contract was governed by English law, and there was no separate choice of law for the arbitration agreement. So that's what gave the English court a jurisdictional foothold. The banks could use the service out gateway for a contract governed by English law on the basis that the relevant contract was the arbitration agreement. So a post-2025 case is FH Holding Moscow and Unicredit, a decision of Mr. Justice Henshaw, handed down in November of last year. So there, the claim was for an ASI to restrain Russian proceedings said to be in breach of an arbitration clause seated in Vienna, with no express choice of law for the arbitration agreement. And under Section 6A, it was common ground that the arbitration agreement was governed by Austrian law as the law of the seat. So then that brings me to my final topic, which is recent developments in anti-enforcement relief. The standout case in 2025 was Google and Tsargrad. In that case, Mr. Justice Henshaw granted orders to restrain various Russian entities from trying to enforce Russian court judgments anywhere outside of Russia. And they were quite extraordinary judgments because they involved Astrent penalties, which were enormous penalties ordered by the Russian court, which doubled every day. So by the time the case came before the commercial court, those penalties amounted to a figure that was 20 trillion times greater than the estimated GDP of all the economies in the world. One estimate of the actual figure was 102 nonillion. And in case you're about to chat GPT that's 1 followed by 30 zeros. So the jurisdictional basis was old case law dating back to 1928, to the fact that if you sue abroad in breach of contract and in violation of equitable principles, you could be restrained in equity from enforcing the judgment you've got. And those remedies are not often granted because considerations of delay and comity often make them inappropriate. So it's a rare example where it was granted. And a point of particular interest is that 2 months later, essentially the same dispute came before Judge Davila in the Northern Circuit, in the Northern District of California. And he also granted anti-enforcement relief, but the jurisdictional basis was an implied term of the arbitration clause. So he allowed, so he was able to grant the relief based on a contractual basis as opposed to the equitable basis in England. And on comity, Judge Davila saw the force of the objection that restraining enforcement was particularly likely to infringe comity, but that, in his view, was outweighed by considerations such as the fact that the Russian judgment, as he saw it, was a culmination of an effort to frustrate the US court jurisdiction in violation of US public policy, as well as the grossly excessive penalties. So where does that leave us? 3 points I mentioned at the start. First of all, 6A of the Arbitration Act 2025 will make it easier to support English-seated arbitrations, for English courts to support English-seated arbitrations. So be careful when choosing your seat. If the arbitration agreement is foreign-seated, then unless you have some other anchor, the English court will have no jurisdictional gateway to ground jurisdiction. Secondly, anti-suit injunctions can increase international risk. So you should consider how your clients will manage their business and the risk their business faces globally if they're a multinational corporate, for example. So consider early where the key assets and counterparties are. and whether your clients can tolerate risk escalating in other jurisdictions where they operate. And then finally, every step of the way from framing your evidence to drafting the order, keep in mind the importance of conveying to the court that you're applying to that this is directed to the party and not to the foreign court. So with that, I'll hand over to Simon.
Before we move to Simon, I just wanted to see whether any of our other panellists wanted to come in on the subject of ASIs before we move off them.
I just maybe a short comment from me, which is to say that I entirely concur with Maya's analysis about what the changes, the legislative changes to the Arbitration Act mean for the English courts' power to intervene with respect to arbitrations that are seated elsewhere, so that the Ruskem Alliance type cases will no longer lend themselves to the issuance of anti-suit injunctions in principle from the English courts. And that I see as a welcome development and as a reinforcement of party autonomy, which is one of the founding principles of arbitration. The parties chose Vienna, as I think in one of the cases, Maya, you mentioned the Justice Fenshaw's case, or Paris in the Ruskem Alliance Unicredit case. If the parties choose Paris or Vienna as their arbitral seat, then it follows that they should go to the Viennese or the French courts as the juge d'appui or the courier court to support their proceedings or to uphold the arbitration agreement, rather than to a third court, such as the English court. And that, I think, creates greater certainty and I dare say perhaps some due deference to international comity, which in this day and age seems to be in some retreat. So I see it as no bad thing.
I think it's interesting to look at all the cases together, because it seems like the English courts are moving away from international policing, as they have to with the new Arbitration Act at the injunction level. But then with the Google case, they are policing internationally, if you term it like that, at the enforcement stage. So I think that's a sort of interesting development to watch. Did anyone else want to come into that? In that case, Simon, over to you.
Thanks very much indeed. Good evening, ladies and gentlemen. Thank you all for coming. I'm going to be talking about recent developments, or how 2025 panned out in relation to the challenge sections of the Arbitration Act, sections 67, 68 and 69. And as Claire said, it hasn't been a year, unfortunately, when there's been some great blockbuster which has set the whole arbitration community buzzing. But there are some interesting cases and some useful cases to have in mind. I'm going to start with section 68. Challenges for serious irregularity affecting the tribunal, the proceedings and the award. This continues to be a real staple of commercial court work. Maya referred to the general caseload which the commercial court deals with in terms of arbitrations, but section 68 is a growth industry, and we all know why. Because section 68 challenges are relied upon by the desperate very often to try to either overturn the award or to try to delay enforcement in a particular country. Up in 2025 from 39 in 2024 to 48, and of the 39 in 2024, only 8 succeeded. It's a surprising and perhaps rather distressing feature of international arbitration that tribunals, even of very considerable distinction, fall down on what you might think is a basic, namely to deal fairly and properly with the issues which have been put before them and in the arbitration. And 2025 saw two interesting examples of successful Section 68 challenges at either end of the spectrum. First of all, failing to deal with an issue that was put to them, to the tribunal, and secondly, which I always find very difficult to countenance, deciding the case on the basis of an argument which wasn't put to them, and without raising that with any of the parties. It just sort of comes in, Deus ex machina like, at the end. The first problem was dealt with this year in an interesting case, Republic of Kazakhstan and worldwide minerals. Now, for those of you in arbitration practice, that might sound like an echo, and it is an echo. It's an unsocial arbitration in relation to causation and loss in an investor-state arbitration. The tribunal is extremely distinguished: Sir Franklin Berman, Professor John Crook, and latterly Professor Rusty Park. Why does it sound an echo? Because unfortunately the arbitrators have been around this course once before. It was a second outing for the arbitrators. In 2020, Kazakhstan brought a successful challenge under Section 68 because the tribunal awarded damages on the basis of a point that hadn't been argued at all. It was then remitted to be dealt with for causation and loss by the judge, Judge Pelling. So they got it wrong that way. This year, it was a successful challenge because they got it wrong the other way. The second award fared no better. This time, the tribunal failed to deal at all with an issue, notwithstanding, in a very long award, I'll tell you how long it was in a minute, having identified what they rather pompously called their route map for all the issues they were going to deal with in the arbitration and then didn't. There's a very useful judgment of Mr. Justice Bryan, which I think is the latest word on, was a point put, was it dealt with? It contains a really good analysis of how the point should be argued. The judgment is notable for three other things. WMM argued, because it was an unsuch trial arbitration, that Article 37 applied, namely that the challenge was barred because Kazakhstan hadn't asked for the interpretation of the award by the arbitrators, to which the judge held, well, this is not an ambiguity case where you need arbitration, interpretation. This is a case, he dealt with this point at the end, where they haven't dealt with the point at all, so why do you need to ask them to interpret a point they haven't dealt with? Secondly, the award had 427 paragraphs over 174 pages. One wonders whether that was really quite necessary. And the argument in the case, it's very entertaining to read how Mr. Justice Bryan deals with it, turned on one sentence of 12 words in one paragraph, the infamous paragraph 293, with which WMM valiantly said implicitly addressed the whole counterfactual issue. It's all about a counterfactual but-for issue without reasons, but it was there somewhere, not a good starting point. And then, perhaps always the plea of the desperate, much reliance was placed on the eminence of the tribunal. Very unlikely, my lord, that having identified the counterfactual issue in their own route, they would have, and counsel's own word, dropped the ball at the last minute. And that was tartly dismissed by Mr. Justice Bryan in these words: the reason why the tribunal went wrong is because the tribunal went wrong. Experience, this may apply to some of us all, unfortunately does not bring with it infallibility. So that was that aspect. The same point applied in another case, Mari Nova and Shanghai Yang Ship Engineering. This is a claim for a breach of a ship repair contract. The Chinese yard didn't bother to attend the arbitration. The claimant lost. And they lost on most of their claim because of what the very experienced arbitrator, Ian Gaunt, ex-president of the LMA, held was the discharge of the yard's liability under two clauses of the contract. Problem. No one had ever mentioned the two clauses of the contract. The Chinese yard didn't, because they didn't participate in the arbitration, and the arbitrator didn't bother to mention it during the oral hearing when the arguments were raised. The claimant applied under both Section 68 and Section 69, and I think there's a reason why they did that. I don't know whether Chirag Karia was a successful counsel. He's not in the room tonight. Judge Kaiser, KC, allowed the Section 68 challenge effectively as a matter of course. Hopeless. But then, interestingly, what he then went on to do, having heard the argument on Section 69 didn't arise, because it should just be Section 68, award set aside and remitted. He went through the Section 69 arguments, held the case was absolutely hopeless, the arbitrator was plainly wrong, and then remitted it to the arbitrator saying, I make no directions about what happens next. So the double barrel worked very, very well. And lastly of note, in rounding off Section 68 for 2025, we've heard about Nigeria and PNID. Is another judgment of Mr. Justice Robin Knowles, where he returns to the same sorts of fraud allegations which were dealt with in the Nigeria case, in a case called K2 and B. a tribunal had made an award in K2's favour against B in relation to a success fee due under a contract, a letter of engagement. B lost. After losing, B applied under Section 68, relying on Nigerian PNID, on the basis that the LOE was I quote, a contract for the doing of fraud, close quote. Problem. They hadn't raised that argument at all in the arbitration, so it was a real afterthought. They said, well, afterthoughts happen. Look what happened in the Nigeria case. And they said that the award, because it was about a contract for fraud, was contrary to public policy. There's a really good analysis by Robin Knowles of his own judgment in Nigeria and PNID, where he points out that wasn't what Nigerian PNID was about at all. It was about fraud affecting the arbitral process itself, which therefore tainted the award. This was very different. It's a really good read. That's Section 68, and I think Section 68 is going to be busy for us again this year. I'll deal next with Section 69, applications for permission to appeal. As with Section 68, always a growth industry for us, commercial court barristers, an increase over 2024 to 73 applications, with 18 being granted permission to appeal. Too early to say how many of those will actually succeed ultimately. In 2024, only 14 were granted permission, but only 4 succeeded. And an interesting issue which come up, and it's come up in the last 5 years and came up in one case this year, is the interaction between the Section 69 permission thresholds, all those things we have to tick the boxes on when you're making an application for permission to appeal, and what the threshold is at the full appeal if you get permission. And that was discussed in the Aston Martin case by Mr. Justice Robert Bright, Aston Martin Mina and Aston Martin Lagonda. Interesting for 2 reasons. Question of construction of a clause in a distributorship agreement, an appeal, the tribunal got it wrong. The appeal was in substance dismissed. But it was argued in support of the award that the court on a full appeal should still apply the obviously wrong test, which it would have applied at the permission to appeal stage. So you've got this super threshold, both at permission and on arguing the full appeal, rejected out of hand by Mr. Justice Bright. The obviously wrong threshold is a filter to winnow out the bad cases. It's not then to determine how the case, if it has been given permission, is to be argued. You're either right or wrong. You don't have to be obviously right or obviously wrong. But of real interest, and I think this is going to be something that's going to come back based on this case in Section 69 applications in the future, was the judge's remarks on how you approach a question of construction on a Section 69 appeal. Especially where factual matrix is involved or may be relevant to the question of construction. It had been in that case. Is a question of construction a pure question of law, or is it a question of mixed fact and law? Because very often when you're taking into account factual matrix on questions of construction, there are factual aspects which need to be dealt with. Mr. Justice Bright erred to the fact that under modern principles of interpretation, it might be a mixed question. And then he asked the question, well, where does that leave the court on a Section 69 appeal? They didn't hear the evidence. They weren't in the evidentiary hearing. All the court has is the award and the contract and the question of construction. Should the court be deferring more to the tribunal who's heard those arguments at much greater length than the court will or can ever do? And I think he's stored up some questions for us there. I bet that case is decided late last year. I bet that case is going to figure now in Section 69 applications when someone's resisting an application to appeal against an award on construction of the contract. My final word, I can feel Claire twitching, my timekeeping is never famous, is on Section 67, challenges to the jurisdiction. Volumes on these sort of applications tend to be pretty steady. 21 in 2024, 24 in 2025. Of the 21 in 2024, only 3 succeeded. 2 big cases which have been of note, in investment treaty work, Czech Republic and DIAG, which failed in the Court of Appeal. The Supreme Court permission has been given on one issue, the important issue of de facto control. And Korean and Elliott Associates, where the very, very powerful judgment of Mr. Justice Foxon was set aside. The matter has been remitted in relation to what actually constitutes a jurisdictional challenge and how you should be construing an investment treaty. And I want to leave you with one entertaining case, which was decided very late last year, A1 against P, just before Christmas. And that concerned the usual authority of solicitors representing a party in an arbitration. A contract had been entered into by the solicitors with some sort of spy warfare, intelligence agency, investigation department to dig up lots of evidence against the other party. It wasn't really about the arbitration, it was about the intelligence agency suing the party, saying, well, you're party to my contract, I haven't been paid, I want to get paid. And it was argued by the party, well, my solicitors exceeded their usual authority, I didn't authorise this. And the challenge succeeded. But what's interesting about it is that it was a full de novo hearing. And we all know from the huge debate that went on about Section 67 in the first draft of the Law Commission, and the second draft and the third draft for the Arbitration Act of 2025, that there's a big feeling, oh, de novo hearings, this should be excluded. And that led to a big debate about how you should legislate for that, which those parties favouring an absolute abolition of the de novo hearing lost. And we've got Section 67, subsections 3b and 3c, which provide for rules of court to be made governing Section 67 challenges in the future. Crystal ball for 2026, those rules of court are going to come in sometime in this year. That's been already mooted by the commercial court judges in a talk in December. Will they make any difference? There's a very good analysis in a recent article in Arbitration International by Sir Richard Akins and co., the people who pushed back against the original version of Section 67 in the 2025 Act draft. It doesn't make any difference. The court has exercised a full range of different procedural routes. So I think that an event of 2026 will be the new rules, but I suspect it's going to be a non-event. Thank you very much.
Thank you, thank you. It seems to me, listening to that arbitration has moved a very long way from its roots of being, one-stop shop, swift decision, for commercial parties, so that they could get on with business. It's a great industry. It's probably welcome news to most of you in this room in any event.
But I think the commercial court is very alive to that. So Section 69 has got the permission filter, which is statutory, but the commercial court itself introduced a filter for both Section 68, and then they extended it to Section 67, which is you can actually apply to have the case struck out and dismissed on paper with a very, very short oral argument afterwards. And those are succeeding a lot in clearing a lot of the ground out of the way. So not many cases get through. So while there's a growth industry, we're all busy drafting the applications, it doesn't necessarily mean we're ever going to get court time.
Sam, did you have a comment to make there?
Yeah, maybe just three brief comments, which are all quite disparate. The first one is I'm actually a big fan of WWM and Kazakhstan. Anyone who's tried to run a causation argument in an investment treaty case will know that it is a really poorly developed doctrine under international law and under international investment law particularly. And you can contrast that with the rich tapestry of jurisprudence that we have on causation in most domestic legal systems. So I think the fact that we have the English courts sort of issuing a warning signal to tribunals that this is a doctrine that has to be taken seriously is a very welcome thing, and will be very welcome for parties and lawyers who are trying to rely upon causation as a defence to these types of claims. The second comment is perhaps a little bit more pedestrian, but I think the Marinova case is a warning sign to a completely different category of people, which is arbitrators and tribunals trying to deal with arbitrations where you have a defaulting party that's not showing up, and the importance in that situation of not essentially sort of disregarding the fact that there is still an adversarial process unfolding in front of you, but making sure that any arguments that occur to you, whether it's for the claimant or for the defendant, are fairly put to both parties, even if one of them isn't actually there in front of you. And then the last comment is perhaps, as Reza did on the anti-suit injunction cases, and Claire as well, just sort of taking a step back and looking at this case law from a macro level, in the same way as we see the court sort of struggling, not struggling, sorry, but dealing with this question of comity and where to draw the line there in the injunction cases in particular. With these cases, we're obviously seeing the court dealing with this question of where to draw the boundary between court and tribunal and arbitral jurisdiction, and the court's role of policing that jurisdiction. And the answer that we're hearing from the English courts is not to just pay blind deference to what it is that tribunals are deciding, eminent or not. We see them taking a very critical approach, very detailed approach, in particular, I think, contrasting the two Knowles decisions as to the impact of fraud, the difference between fraud on a contract and fraud in the process itself. And I think that is extremely welcome. And again, just sort of setting a good example, frankly, in a world that really needs some good examples of critical thinking and dedication to the rule of law.
Well, thank you. So I think without further comment, we should probably try and keep our timing on track, and I'll come to the audience for questions at the end, and move to Reza.
Very good, thank you, and good evening, everyone. So I'm going to discuss a single judgment rendered by the Court of Appeal in the summer that's going to be considered by the Supreme Court, I understand, in June. The case is Star Hydro Power Limited and National Transmission and Dispatch Company. And to my mind, at least, it raises interesting questions about, first of all, the application of the New York Convention, particularly whether it can be used preemptively. And second, and this is the theme of the evening, it seems, the role and powers of the English court, acting here as the curial court, in monitoring what's being done by other courts, in this case, their application or interpretation of the New York Convention. It's an anti-suit injunction case as well, just to keep with our theme. So the case arose out of an underlying arbitration commenced by Star Hydro, which is one of a number of independent power producers, IPPs, generating electricity in Pakistan, and selling that electricity to this state-owned off-taker called National Transmission and Dispatch Company, NTDC for short, under a long-term power purchase agreement, PPA. This is one of many dozens of cases that have arisen in arbitration over the last decade or so between NTDC on the one hand and the slew of IPPs on the other. They all have the same arbitration provisions, providing for LCIA arbitration, a London seat, Pakistani governing law. The arbitration here concerned a dispute over the adjustment of tariffs under the PPA to reflect the increased cost of the project by reference to a contractual adjustment mechanism. In response, NTDC's defense was that under Pakistani law, the regulator, the national electricity regulator, had the power to set tariffs. It had done so in this case, and therefore the arbitrator had no power to use this contractual mechanism to adjust the tariffs. And effectively, Star Hydro's claim was inadmissible as a matter of Pakistani law. The sole arbitrator rendered an award, which was a bit of a mixed bag. He upheld, and that's being polite, I think, he upheld that the regulator did indeed have power to set the tariffs, and it had done so. And so from the moment that the adjusted tariffs had been set by the regulator, looking forwards, he had no power to adjust that tariff. And this was a long-term 30-year agreement. And so that's an important victory for NTDC in the case, but the arbitrator also held that for the initial 3 years of operations, this is before the regulator had set the tariffs, had adjusted the tariffs, the arbitrator had the power to contractually adjust the tariffs. He had done so, and that had led to an award of damages in favor of Star Hydro. So an award in which there are losers and winners on both sides of the fence. Neither party challenges the award in London, the seat of the arbitration, but NTDC brings enforcement proceedings under the New York Convention in Pakistan before the Lahore courts, seeking to enforce a single sentence, a single dispositive part of the award, the pro forma finding by the tribunal that says all other claims and relief is hereby dismissed. That's the bit NTDC wants to recognize, and it goes on to seek a declaration that the rest of the award, notably the parts awarding damages to Star Hydro, should not be recognized because of the grounds of the New York Convention, Article 5, 2 dealing with inadmissibility, beg your pardon, in the findings being not arbitrable as a matter of the enforcing court's law, but also as a matter of Pakistani public policy. Star Hydro goes to the English court seeking an anti-suit injunction on the basis that what's been done by NTDC is a breach of the arbitration agreement and is vexatious. At first instance, the English court rejects the application for an anti-suit injunction. The court holds that England, yes, was the supervisory jurisdiction, but NTDC was entitled to apply in Pakistan under the New York Convention for partial recognition and enforcement of the award, and was also entitled to preemptively assert that parts of the award should not be recognized or enforced in Pakistan. The court went on to hold there was nothing in the text of the New York Convention itself to limit the right to seek recognition and enforcement to only one party or another, especially in cases where there are parts of the award where you've won or parts of the award where you may have lost, and that the court must assume that the enforcing court that has been approached will comply with its international obligations under the convention. And so the English court doesn't have this policing function over enforcing courts. The decision goes up to the Court of Appeal, which disagrees, sets aside the first instance judgment, and indeed issues a permanent anti-suit injunction. And let me just quickly run through the main reasoning of the court, whose judgment is delivered by Lord Justice Phillips. And I think the judgment is quite significant for a few reasons. First, the court holds that the courts of the seat have exclusive jurisdiction over challenges to the award. No debate there. That the court affirmed its readiness to issue anti-suit injunctions to restrain proceedings outside of England that are brought in breach of arbitration agreements. Fine, again, not controversial. Third, that the court reiterated that this approach applied with even more force to proceedings where proceedings that have been brought abroad to challenge or invalidate an award in a foreign jurisdiction when England is the seat of the arbitration. In this respect, Lord Justice Phillips refers to an earlier 2018 judgment, Atlas Power, which he himself had rendered when the commercial court. It was a case involving NTDC and other IPBs where NTDC had lost a London-seated award, and in that instance had sought to annul the award, both in London and in Lahore, on the basis that the Pakistani courts had concurrent jurisdiction together with the English courts on the basis that the arbitration agreement was governed by Pakistani law. And so for Mr. Justice Phillips, I beg your pardon, Lord Justice Phillips, the present case had very strong echoes of what NTDC had tried to do nearly a decade earlier. The court then considers the text of the New York Convention and finds that from its review of Article 5, challenges to an award under the Convention are a shield against applications for recognition and enforcement, and not a sword by which an award may be attacked preemptively, and so that the Convention grounds of Article 5 can only operate, according to the court, as a defensive mechanism. And in that respect, the court looks at how the New York Convention has been implemented under English law by reference to Section 103 of the Arbitration Act, whereby the court holds the Convention operates solely by way of opposition to an enforcement action. The court then does not accept that the labeling of NTDC's application in Lahore as being under the New York Convention should cause the English courts to have to leave the matter to the Pakistani courts. Star Hydro, it holds, was entitled to ask the English courts to consider those proceedings and to enforce the arbitration agreement if the foreign proceedings were brought in breach of the agreement to arbitrate. And the court indeed goes through NTDC's application to the Pakistani courts with a fine-tooth comb, and leading to its conclusion that this was a vexatious or a disguised attack against a London-seated award. So those are the main building blocks of the judgment. And let me just conclude by raising three observations with you very briefly. First, it's clear that Lord Justice Phillips's consideration of NTDC's application in this case was coloured by his earlier judgment in 2018, when he had to consider a much more blatant attack to a London-seated award by NTDC. Indeed, the very final concluding paragraph of the judgment, Lord Justice Phillips finds that NTDC's present challenge to the award is the same type of challenge as was injuncted in the earlier case in 2018, and that NTDC, having failed last time, this time seeks to justify the same impermissible conduct by seeking to frame the challenge under the New York Convention. Let me, at this point, declare a personal interest and say that I acted as counsel to the claimant IPPs in the earlier case, back in 2018, and I sought the anti-suit injunction granted by the court against NTDC. And I have to say that beyond the superficial parallels, I see NTDC's actions in the present case to be materially different. This was a much more even award with a nuanced split outcome in which NTDC had prevailed in a large measure. Unlike in 2018, NTDC was not seeking to overturn or set aside the award on grounds of concurrent jurisdiction in Lahore. NTDC's approach was much more nuanced. Second, there is the court's firm view that the New York Convention cannot be used preemptively, that the grounds for non-recognition in Article 5 may only be invoked as a shield once a recognition application has been raised by the winning party. And again, I admit I struggle with that construction of the New York Convention. Article 5(2) of the New York Convention, which goes on to list the arbitrability and public policy exceptions, says that recognition and enforcement of an award may also be refused if the competent authority in the court where recognition and enforcement are sought finds, and then sets out those two grounds. There's nothing here about it being responsive or a shield. And as I've already mentioned, NTDC did seek to recognize the award, albeit in part, while seeking declarations that the remainder of the award should not be recognized by reference to the New York Convention. And thirdly and finally, is the question about the monitoring or the policing or role of the English courts as the curial court. In circumstances where the award has been rendered, the tribunal of functus officio, no set-aside application has been brought before the English court. What further role does the curial court have to monitor and police the application of the New York Convention by foreign enforcing courts? Does the English court really have the power to review and pass finally through applications based on the New York Convention brought before foreign courts before determining whether the foreign court should consider those applications or not? That I find to be of potentially very far-reaching consequence. And I'm interested in others' view in this. Thank you.
It will be very interesting to see what the Supreme Court makes of
Who granted
those
permission to the Supreme
questions.
Court?
It did,
Yeah.
Yeah, that's definitely one to think about and watch over the year to come. Would anyone else like to come in on Star Hydro?
It doesn't sound like anything like the first case. I agree with you.
It doesn't.
Completely different. Completely different.
And just as another interesting anecdote, my co-counsel in the first case, my Pakistani co-counsel, have now switched sides and are representing NCDC in this case. No doubt they have taken lessons from what happened last time.
Steeped in experience.
Yes.
Well, very interesting, and as I say, one to watch. So now that brings us to our last speaker of the evening, Sam, who's going to talk about some of the investor state cases that have touched this jurisdiction.
Yes, thank you, Claire, and thank you to Quadrant Chambers for inviting me this evening. So not many cases to discuss tonight, and I'll try and cover a few more developments as well, depending on how much time I have. But those that we do have are certainly notable in terms of the importance of the principles on which they touch, and also the consequences that they have for parties to ICSID proceedings and their interactions with the courts of England and Wales. So the first decision that I'm going to touch on tonight came out of the Court of Appeal last year, and it was Infrastructure Services, Luxembourg, Sal and Spain. A decision that actually arose out of two appeals from two different attempts to register ICSID awards in the English courts, one the infrastructure case against Spain, and another an ICSID award that had been obtained against Zimbabwe. In both of those cases, the High Court registered the ICSID award, and in both of those cases, the respondent state sought to set aside that registration on the grounds that they were immune from the jurisdiction of the English courts. The State Immunity Act, of course, provides us the bedrock principle, it's a bedrock principle of international law as well, that a state is immune from the courts, from the jurisdiction of the courts of the United Kingdom, except as otherwise provided in this act. And what the appeals in both cases ultimately turned on was whether in the ICSID Convention, a state, Spain and Zimbabwe in these cases, whether the ICSID proceedings had arisen by a prior written, whether a state is submitted after the dispute giving rise to the proceedings had arisen, or by a prior written agreement that it is to be governed by the law of the United Kingdom. So essentially, does the ICSID Convention contain a written agreement to submit to the jurisdiction of the English courts? And the argument made by both claimants was that under Article 54 of the ICSID Convention, which provides that each contracting state shall recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in that state, that by becoming a party to the ICSID Convention, this was a written submission to the jurisdiction of the English courts as concerns ICSID awards rendered against them. Now, the High Court in both cases sided with the claimants, albeit for different reasons. So in the Spain case, Mr. Justice Fraser actually looked first to the ICSID Convention and said, look, under the ICSID Convention, as implemented in English law, Spain has submitted to the jurisdiction of the English courts, so no need to look at anything further. But if I were to look at the State Immunity Act, I would find that the Article 54 of the ICSID Convention is a written submission to jurisdiction. And then there is a further issue under Section 9, but I'm not going to go there out of the interest of time. In the Zimbabwe case, on the other hand, Mrs. Justice Diaz found that there was actually no question of submission to the jurisdiction of the English courts when you're seeking to register an an ICSID award, which she referred to as essentially an administrative act, a ministerial act, as opposed to the submission of the adjudicatory jurisdiction of the courts. And she said that if she were asked to decide whether or not Article 54 contained a written agreement to submit to jurisdiction, her answer would be no, because while it contained a clear submission to jurisdiction, it wasn't sufficiently clear as to the identity of the parties or the identity of the relevant dispute. It was essentially too vague. The Court of Appeal took up both appeals from Spain and from Zimbabwe and actually reached a sort of different landing from both of the High Court decisions. So disagreed with Mr. Justice Fraser's attempt to sort of bypass the State Immunity Act altogether by looking first at the ICSID Convention, but also disagreeing with Mrs. Justice Diaz that registration of an ICSID award doesn't require submission to the adjudicatory jurisdiction of the English courts. He found no, of course it does, so the State Immunity Act is engaged. However, the Court of Appeal went on to find that Article 54 does contain a written submission to the jurisdiction of the English courts by all states to the ICSID Convention. Essentially applied a VCLT analysis, looked at the language of Article 54 itself, said that Article 55 deals with the continuing immunity to execution. So when read in light of that, Article 54 must in fact be a submission to adjudicatory jurisdiction. And in doing so, essentially aligned the English courts with decisions coming out of a number of other major enforcement jurisdictions, including Australia and others. And it is worth noting that the Spain cases have been a real gift in terms of generating an enormous amount of jurisprudence around how domestic courts deal with ICSID awards. And perhaps reassuring to see the English courts, in this case at least, align themselves with the other major jurisdictions where claimants tend to seek enforcement. On the other hand, we also had last year a decision out of the High Court in the case of Opera Fund and Spain, another Spanish renewables case. A party called Blasket Renewables Investment LLC, the claimant to the original ICSID arbitration against Spain, had won an award of about $30 million against Spain, applied to the High Court for recognition of the ICSID award. After those proceedings had started, as with many claimants in the Spanish renewables case, essentially sought to monetize its award by assigning it in an assignment agreement, essentially assigning all of their interest in the ICSID award to an assignee, to essentially a funder or an investor picking up these awards in the market. The investor and the assignee then filed a joint application to the High Court for the assignee to be substituted for the investors pursuant to the CPR 19.24 in the registration proceedings. Spain opposed this application, arguing that ICSID awards are not assignable. The High Court in this case actually ultimately sided with Spain and found that ICSID awards are in fact not assignable. again adopting a VCLT analysis of the ICSID convention. In this case, the court basically said that the convention refers interchangeably to a party and a party to the dispute, so those must mean one and the same thing, and that means that in order to be able to get an award recognised and enforced, you need a party to the dispute and not just a party, a third party. They also looked to the ECT, which contains a subrogation clause, and found that the existence of the subrogation clause, so the fact that in a certain set of circumstances a third party may step into the shoes of the investor, excludes any other possibility of assigning rights under that treaty as well. And when it was pointed out to the High Court that this approach was sort of diametrically opposed to the approach taken by courts in Australia and the United States, the response of the High Court was, well, they were looking at this under their domestic law and we're looking at it under international law. We're right, they're wrong. ICSID awards can't be assigned, which has had a pretty monumental impact actually on the market that surrounds ICSID claims. Claimants in these cases are often either impecunious or close to impecuniosity and essentially looking to realise some money from the proceedings as quickly as possible. And a great big secondary market has built up around that, which has been, as I say, sort of seriously impacted by this decision. So we'll wait to see what the Court of Appeal does with this year. Perhaps just very quickly, just a few other things that I picked up on in preparation for this session. Last year, we also saw the first ICSID claim against the United Kingdom, which has been brought by a Singaporean company and its English subsidiary in relation to court proceedings and administrative decisions around a potential coal mining project in Cumbria. So not much more to say other than that the case has been filed and watch this space. We've had more fracas between the European Union and the UK following the CJEU's decision, that the Mikula decision, where the English courts recognised an ICSID award that Mikula had obtained, essentially disregarding the intra-EU objection, was in breach of EU law. We've had another complaint filed by the European Union, this time relating to the UK's recalcitrance, shall we say, to withdraw from all of its intra-EU bilateral investment treaties and to take steps against UK investors that are engaged in intra-EU arbitrations against EU states. On the other hand, we've had the UK-India FTA signed last year. It doesn't contain any ISDS provisions yet, but apparently those are still under negotiation and the UK government is pushing for them. So again, that's something to look out for this year. And with that, I think I'm probably at time, so I will pause and hand back to Claire.
Thank you, Sam. I think the Opera Fund decision is really interesting because it's a second shockwave in the litigation funding market, essentially. So you've got PACCAR that is now going to be dealt with on a legislative basis, and now this as well. So you know, it's obviously something that's of real importance to parties and those who are instructed by them on a funded basis. Did anyone else from the panel want to come in on any of the ISDS stuff before I hand the floor over to our guests? Okay, well, with that, we've got about 5 minutes, and obviously there's a small amount of material to cover there. But I can see, is that Graham? Do you want to come in?
Does it work? Yes, it works. Thank you. Thank you very much, everyone. Graham Coop, the Plimpton Masons, where I'm head of public international law and co-head of investor state dispute settlement. Thank you very much to all the panelists and, of course, our gracious chair for these wonderful presentations, all of which I found fascinating. I have a particular question or observation directed to Reza's presentation. Thank you for enlightening me about the Star Hydro case, with which I was not previously familiar, and it is a fascinating case or pair of cases. And I suppose an observation, and I'm revealing my age a little, by saying that I remember when the Hill Martin decision in, I think, the Paris Court of Appeal, at any rate in France, was fairly new on the block. And that decision, of course, looked at the issue of whether may and must synonymous under Article 5 of the New York Convention. In other words, whether if a party resisting enforcement manages to establish one of the grounds in Article 5, the court where enforcement is sought must refuse enforcement or only may refuse enforcement as a matter of discretion. The issue in Hillmartin, of course, being the fact that the award in question had been annulled by its court of the seat of arbitration, and this is a ground under Article 5, I think it's 51E, does the court where enforcement is sought have to refuse enforcement or not? And the Paris court held that it did not have to, as I recall. So it's a philosophical question, really. Do you see a difference? Because I've only started thinking about this 15 minutes ago, but I'm starting to see a difference between a court such as the English court effectively forbidding enforcement when, supposing the ground to be established, it would have to refuse enforcement on one hand. That's the non-Hillmartin approach. Or on the other hand, the Hillmartin approach. If the English court, when it came to dealing with a request for enforcement, would have discretion, then is it in some way fettering that discretion by ruling on the question before it actually has to? I think that's my question. I apologize, it's a bit complicated.
It's a really good question, Graham, that I would need to ponder carefully. But I think I don't view this as being in the same paradigm as Hillmartin. This, for me, fundamentally is about the New York Convention, the spirit and the letter of the New York Convention, which signatory states have undertaken to enforce into their domestic law. And once that domestic law is engaged by a party seeking enforcement under the New York Convention, then to my mind, it's for that enforcing court to determine the application of to determine that application based upon its interpretation of the New York Convention. It shouldn't fall to the courts at the seat of the arbitration to monitor or police the application of the New York Convention in a third state. That's the bit that I struggle with.
Especially on the assumption that the third state will faithfully try to construe the New York Convention in accordance with the Vienna Convention on the Law of Treaties.
Indeed.
Yeah, there may be, you raise your eyebrows, that may be an unreal expectation. But I mean, it's wrong for the English court to say we're the experts on the Vienna Law of Treaties and our interpretation is better than anybody else's.
Okay, so we've covered some philosophy there. So would anyone thank you, Graham. Would anyone else have any questions for our panel?
Maybe I had a question.
Oh, okay.
For Sam. I mean, what do you think the impact of the High Court's decision will be on the assignment of ICSID awards? Because as you say, there is quite a vibrant secondary market for the sale of these things.
I think everybody is expecting the decision to be overturned by the Court of Appeal. Honestly, I don't think anyone thinks that this is going to be the law, the English law on this point. It would seriously diminish the sort of legal market for enforcement around ICSID awards. It just throws up too many question marks. And as Claire rightly said, we've already caused a little bit of consternation in the litigation funding community. And we know, for example, that litigation funders are either not electing English law to govern their contracts anymore, or they're thinking very seriously about it. And this just seems to be another step towards diminishing our credibility as a jurisdiction. It's sort of ignoring the commercial realities of these claims and how they tend to unfold.
You said that the English court had distinguished the Australian and New York authorities on the basis they were dealing with it as a matter of domestic law, whereas we are dealing with it with the Vienna Convention habit. Was that right?
Yeah, I mean, it is an accurate, yes, it's an accurate description of the basis on which it, but I think, isn't there a question mark as to whether actually the US and the Australian courts were right on this point? I find it sort of I'm not sure it's self-evident that the ICSID convention would govern the assignment of awards rendered under the convention. There does come up, exactly, there comes a point where international law stops and domestic law picks up the mantle. And I think it's, at the very least, it's arguable that when you're talking about assignability, you've crossed that line.
Who was the judge?
Oh gosh,
Doesn't matter.
give me a
I'll look
second.
it up.
It'll be in my notes somewhere.
I think it was Pelling.
Yeah.
I think it was Pelling.
Yeah.
At that point, we are at an hour and a quarter, which is our allotted time for this session. I think our panel will stay around for some drinks. I invite you all to do the same. The drinks will be at the back of,
They're already
back
poured,
of this
ladies
room.
and gentlemen.
I can see they're poised there, so you don't have to go far. But before we do that, I would like to thank our audience for coming out on a rainy, cold January night to be a very receptive audience and to have a huge amount of information downloaded into the room. So thank you for being a great audience tonight. And I'd also ask you to thank our panel in the usual way.